Good morning. Happy Tuesday. I saw a video of Chille's arraignment yesterday for the second interfering charge that he got, allegedly just for filming the police. And I had to stop watching it. I was laughing so fucking hard when he started going off. I smelled it in the water when he started asking, like, who is the prosecutor? Who's the prosecutor? But I died laughing when he said that he was going to sue the prosecutor for malicious prosecution. So my best guess is he's not going to sue under the state court or under the state common law tort of malicious prosecution, but rather he's most likely going to sue for a Fourth Amendment violation for malicious prosecution. They're different, they're not the same. And the reason why I think he's going to sue under the 1983 lawsuit for malicious prosecution is because it's my understanding that he was citing Thompson versus Clark, which was a 1983 lawsuit where the plaintiff said that his Fourth Amendment rights were violated by actions taken by the police. So it didn't involve a prosecutor, it involved the police. And the Supreme Court in that case held that you didn't have to get a favorable outcome. You didn't have to be found not guilty. You just had to be, the case just had to be dismissed basically what is sufficient. It's sufficient just to have the charges dropped and the case dismissed. You don't have to be found not guilty. So that's what leads me to believe that he's going to sue under 1983. However, there's a real problem with him trying to sue a prosecutor under 1983, and that's Imbler versus Pachtman and Buckley versus Fitzsimmons. There's two Supreme Court cases out there, at least on it. There's two big ones that I'm aware of. There's probably more. The net result is that if the prosecutor is doing everything like in his discretionary functions and he's not doing anything that is outside of his, like, I'm bringing this against you because, well, it's my job as a prosecutor to prosecute charges that have been filed. You know, if it's within that scope, just like a judge would have absolute immunity, a prosecutor has absolute immunity within that scope. Now there's Buckley versus Fitzsimmons. It changed things a little bit because if the prosecutor is doing things that would be within the ambit of like the police, if the prosecutor is taking over detective kind of functions, like some prosecutors' offices have investigators attached to them, they would lose the absolute immunity for things done under that purview. Because in Buckley, I think there was they tried to match some forensic evidence. I forget what it was. I think it was like footprints, boot prints, or maybe it wasn't a blood sample. Anyway, they were trying to match forensic evidence, and they ran it by like two or three reputable forensic companies that, you know, analyze the forensic evidence, and those said no, that there's no match. And so they went to another party, basically a yes man who would say whatever, another expert who would just say, yeah, sure, it matches even if it didn't match. And based on that, fabricating evidence and getting an expert whose sole function was just to say yes, the U.S. Supreme Court said that absolute immunity doesn't apply because these are the kind of functions that it would be for a police officer or a detective. At least this is my understanding, having read this case in a while. Came out a couple years ago, didn't it? I forget. 2010? Like, it came out 15 years ago or so. Anyway, it's been a while since I've read it. But my best recollection is that the court said that absolute immunity would not apply in this situation, but because it would be a function that like police or police detectives would do, qualified immunity would apply because it would apply to the police, etc. So there's already a huge burden in place just trying to sue the prosecutor in the first place. And I'm going to be honest with you, like threatening a lawyer with a lawsuit is about the least threatening thing that you could do to a lawyer, because a lawyer is going to be able to figure out pretty quickly, hashtag generally speaking, hashtag not all, hashtag I'm only talking about competent lawyers, are going to be able to figure out pretty quickly what their liability is, what their exposure is. Like, is there actually a good cause of action available against me, or is it bullshit? You know, how much do I really stand to lose here? A lawyer can figure that out pretty quick and do the math and not really worry that much. It's not that big of a deal. If you know you're liable, and I mean you might just fight it out just to be ornery. But you know, it's not, you don't scare lawyers by threatening a lawyer with a lawsuit. Let's just leave it there. I've never met a lawyer yet who was intimidated by a lawsuit. Oh, you want to file a lawsuit against me? Great. See you in court. But threatening like prosecutors get sued all the time by people that they've prosecuted. It's not uncommon. It's a pretty common thing, and they typically don't get. There's typically nothing that happens to them. It's typically a absolute immunity under California state law. They have immunity. Under Nevada state law, they have immunity. For a 1983 lawsuit, they have immunity. I mean, society would not function if prosecutors weren't allowed to prosecute. You know, that's pretty much just the way it has to be, unfortunately, or fortunately, depending on which side you want to look at. But that's just the first part of the equation. The second step is that Chille would have to prove that there's no probable cause. And I keep going back to this, but you have to remember, probable cause is an insanely low bar. It is very, very hard to show that they don't have probable cause. Reasonable suspicion, forget about it. Forget about it. You can't, unless the cop is a complete fucking imbecile, a cop will have reasonable suspicion. It's really not worth challenging, honestly. I mean, unless the cop's an imbecile, and trust me, there's a lot of cops who are imbeciles out there. I've seen them in videos. But unless the cop's an imbecile, there's going to be reasonable suspicion. But the old saying where you can indict a ham sandwich, that means that you could show probable cause against a ham sandwich. And I didn't even have to say what you're indicting the ham sandwich for. It's an insanely low bar. A crime was probably committed, and you probably committed it. That's what they'd have to show. A crime was probably committed, not that it more likely was committed than wasn't committed, but probably. What percentage is probably? Who knows? Who knows? It's less than 50%. We know that. But how low does it go? I don't know. You don't know. The Supreme Court won't tell us. So a crime was probably committed, and you probably committed it. Boom! Probable cause. The allegations, I believe that there was interference, obstruction, whatever, of a police officer in the course of their performance of their duties, whatever it is in Nevada. Well, was the police officer interfered with? Probably. Did Chille probably do it? Probably. I mean, it's such a low bar. It's stupid. So he's got, like, Chille says all the time, I sue cops. I sue cops. Now he's going to sue a prosecutor. Great. I sue people. Great. But do you win? Do you win? Show me the money. I have seen people who don't pretend to be legal experts, who are auditors, get multiple settlements in the tens of thousands of dollar range in less time than Chille has spent filing all these fucking ridiculous lawsuits and getting bupkis. I mean, show me the money. Thanks for watching. Have a great day.